Hi, my name is Emily Davies Miller, and I will be talking about employment law and In-N-Out Burger. Employment law. Federal and state employment law defines the rights and obligations of employer and employee to one another on the job. Rules under common law, contract, tort, and agency also apply in the employment context. Employment at will is a crucial aspect to many employers in the United States. It means that either party has the power to terminate the employment contract at any time and for any reason. Courts have developed some exceptions to this hard and fast rule, but the assumption is that any employment relationship is at will. And typically, most employers in the United States use some sort of at will rule within their employment contract. Employment contracts. There are several different elements that make up an employment contract that employees may enter with an employer. There's at-will employment contracts that I just discussed before, non-disclosure agreements, intellectual property agreements, non-compete agreements, and independent contractor agreements. These can all be added to an at-will employment agreement or used in exchange. All of these agreements can be used, as I said, and establish different relationships between the two parties. Typically, at-will employment contracts are used across the board and are assumed in most employee-employer relationships throughout the United States. The additional elements listed add extra terms beyond the standard expectations between the parties. Exceptions to at-will contracts. At-will employment contracts allow for both parties to feel in control of the work relationship they have with individuals. Some exceptions exist to the at-will contract agreements, such as implied contract or collective bargaining agreements. Implied contracts are created based on the provisions of an employee manual or promises made by the employer that create the understanding that dismissal will only happen for a good cause. The implied understanding can give rise to a breach of contract claim if the employee is dismissed. Another exception is when an employee claims wrongful discharge. This can occur when abusive discharge procedures cause the employee distress, or if an employer violates a statute during the discharge. A final exception is the collective bargaining agreement, which is a contract between an employer and a union that regulates employees' working conditions and other job-related issues. Its terms are negotiated by the employer and representatives of an employee bargaining unit. At-will employee contract sample. So this is the draft I made of a sample basic employment contract that you would probably see in an In-N-Out Burger environment where they're hiring an employee. In this agreement, in this employee contract agreement, it covers several of the agreements discussed in the previous slides and are most definitely necessary to employ at In-N-Out Burger. And as you can see here, I pointed out the at-will section that is on the first page. So then the contract goes on to explain pay and leave. The employment contract will cover pay and leave and benefits and that they will receive, so there's no discrepancies after the hiring process. The Family and Medical Leave Act of 1993 provides that most employers that employ 50 or more employees must provide an eligible employee up to a total of 12 weeks of unpaid leave during any 12-month period. So you can see here that I included a unpaid leave section that covers those grounds. And in this contract, In-N-Out Burger lays out opportunities for managers to assess the company's policies in regards to leave. So there's also some positions that may receive paid leave. A non-compete agreement, and in this specific employment contract, I chose to include one. It disallows an employee to participate in any activity with any other competition. Every state has its own laws in regard to the enforceability of a non-compete agreement, and in the case of California, the state does not typically permit enforcement of non-compete agreements. They can include one, but the Americans with Disability Act is a federal statute that prevents employers from discriminating against qualified individuals with disabilities, and that requires employers to make reasonable accommodation to applicants and employees with disabilities, unless doing so would cause the employer undue hardship. And in this case, the employment contract that I made for In-N-Out, the phrasing explicitly states that disability would be something that could cause termination due to the hardship it could cause the chain. There's also an independent contractor agreement, which isn't included in this contract that I made. However, I thought I would cover it. An independent contractor is a party hired to perform a specific service. How the independent contractor completes the task is beyond the control of the person who hires him or her. So here you can see an example. And the IRA typically analyzes behavioral factors that would classify an individual as an independent contractor. And in the case of In-N-Out, they may need individuals to provide temporary work without the benefits the company offers. So this could be something that they could possibly include. A non-disclosure agreement. Although not a part of this employment contract, a non-disclosure agreement is a legally enforceable contract that creates a confidential relationship between a person who holds some kind of trade secret and a person whom the secret will be disclosed. In the case of In-N-Out Burger, a typical employee who works within the restaurant doesn't necessarily hold trade secrets of the company. This type of agreement could come into play for the business if, say, a potential employee worked in the test kitchen of In-N-Out Burger and therefore could be included with the contract. Intellectual property rights agreement is another clause that could be added. An intellectual property clause or agreement within an employment contract lays out the groundwork for any sort of idea an employee makes at work belongs to the employer. For example, if an In-N-Out Burger employee worked in the test kitchen and created a new recipe for animal-style fries, they most likely would have signed on an intellectual property agreement with In-N-Out, so the company had established ownership of the recipe. So here's an example of what could be included. Just like many other employers in the United States, In-N-Out Burger would most likely create an at-will-based employment contract that a majority of their employees would sign. The specific clauses and agreements that can be added to employment contracts, such as an intellectual property agreement, non-disclosure agreements, and non-compete agreements, are essential when assessing the circumstances at which an employee will be a part of the business. Overall, employment contracts establish a fundamental relationship between employees and employers from the beginning and are essential to maintaining a functioning business.